James slipped on ice near the loading bay at his sanitation facility on the west side of Chicago. He's on the ground, knee on fire. A coworker helps him up. His supervisor walks over. Knowing what to do after a workplace injury in Illinois right now in the next 60 seconds is the difference between a protected claim and one the insurance company can pick apart. Most workers get this wrong, not because they're careless, because nobody ever told them. Two mistakes in the first few hours are almost impossible to undo later. This is how you avoid both of them. I'm going to give you this in sequence. When you're hurt and in pain and your adrenaline is running, the last thing you need is a lecture. Here's what to do step by step from the moment the injury happens through the first 72 hours. Get medical attention first. If you need emergency care, call 911 or get to an ER. Don't let anybody talk you out of it because it creates paperwork or looks dramatic. Your health comes first, full stop. If the injury isn't life-threatening but needs treatment, and that includes anything still hurting the next morning, get to urgent care or to your doctor as soon as possible. Do not wait to see if it improves. Do not push through for a few days, hoping it settles down. Gaps in medical treatment are one of the primary weapons insurance companies use to argue that an injury wasn't serious or wasn't connected to work. If you waited 2 weeks to get seen, they will point to that every single time. On doctor selection, and under Illinois workers' compensation law, you generally get two choices of treating physicians at the employer's expense, plus the chain of referrals from those providers. Some employers will ask you to go to their clinic first. If your employer has a properly noticed preferred provider network rules may apply for some or all of your treatment. But Illinois generally gives you the right to your own treating physicians at the employer's expense, and you're not locked into the company clinic for the entire course of your care. Know that from day one. Report the injury in writing today. Tell your supervisor or HR what happened as soon as possible. Then follow up in writing the same day. Send an email. Fill out the employer's incident report form and keep a copy for yourself. Text your supervisor basic facts and save that thread. Under the Illinois Workers' Compensation Act, you're required to notify your employer of a work injury within 45 days. But don't use that window as a reason to delay. Report it now. The longer you wait, the harder it becomes to connect the injury to the workplace. The more ammunition you have against the insurance company to question the claim. When you make the report, be specific. Where were you? What were you doing? What happened? What part of your body was injured? Slipped on ice near loading bay, struck left knee on concrete is better than hurt my knee at work. Concrete details make a claim harder to dispute. Document the scene while you can. If you can safely do so, take photos of the area where the injury occurred. The patch of ice, the wet floor, the broken equipment, the missing guard. Take them before anything gets cleaned up, repaired, or removed. Note the names of any coworkers who witnessed what happened. You don't need to make a production of it. Just note who was there. Ask yourself whether there's surveillance video in the area. Surveillance footage gets overwritten on a regular cycle, typically every 30 to 90 days. If a claim is filed properly, your attorney can issue a preservation demand before that footage disappears. Once it's overwritten, it's gone. That evidence is gone with it. Do not give a recorded statement to the insurance company. After the claim is filed, an insurance adjuster is going to call you. It will happen within a few days. The call will sound routine and friendly. They'll ask you if you can record a statement about what happened. Tell them you want to speak with your attorney first. Politely, firmly, without argument. That's it. Recorded statements are a tool. They lock you into specific language about how the injury happened, how you feel, and what your limitations are. If you say anything the insurance company can later interpret as inconsistent with how your injury developed or with the severity you're claiming, they will use it. The adjuster is not your friend in this moment, regardless of how they sound. There's no benefit to giving a recorded statement before you have counsel. There is real, meaningful potential harm. Write down your own account immediately. Get a notebook or open the Notes app on your phone and write down exactly what happened, when and where the injury occurred, what you were doing, what you saw or heard the moments before, what happened right after, what your supervisor said, what you said back. Write this within hours of the injury while the details are sharp. Your memory in the first 24 hours is your most accurate version. 6 months from now, when an attorney or an arbitrator asks you to describe exactly what happened, you'll be glad you wrote it down. Most workers don't bother. The cases suffer for it. Here's something most workers don't realize until it's too late. The notes you write for yourself in the first 24 hours can become critical evidence later. If the insurance company argues the injury happened differently than you've described, your own contemporaneous record is your strongest defense. Take 10 minutes, write it down. Stay off social media. Not a photo, not a status update, not a check-in, nothing. Insurance companies routinely monitor the social media accounts of claimants. A photo of you at a family gathering helping somebody carry something, standing at a cookout, regardless of context, regardless of how much pain you were in that day, will be screenshot and submitted as evidence. Tell your family and close friends nothing about this on any platform while the claim is active. Not a prayer request, not a thinking of my brother who got hurt, nothing. Call an attorney early. Workers' comp attorneys in Illinois work on contingency. Nothing upfront, no hourly fees. You pay nothing unless you recover. There is no financial reason to wait. Calling early means the attorney can guide you through every step, which doctor to choose, whether to give a statement, how to document the scene, what to do if an IME gets scheduled, how to evaluate any settlement offer that arrives. The workers who fare the worst in this system are almost always the ones who waited. They gave a statement they shouldn't have. They used the company doctors for months without knowing they had a choice. They accepted an offer without understanding what their case was worth. The workers who fare best are the ones who knew their rights from day one. You're watching this video. That means you're already ahead of most people. Keep going. If you've received an IME notice, watch my video on what an IME is and why it matters. That's a critical one. Subscribe so you don't miss what we publish every week. And if you want to talk through your situation, Connolly Injury Law offers free consultation. What was your first mistake you made or almost made after a work injury? Drop in the comments. Your experience might help somebody else from making the same call.